in rebuttal. In this matter, Justice Trump is voluntarily disqualified. Judge Mann is sitting by temporary assignment.
Before we get started, welcome Judge Mann. I think your first time sitting with us on the bench. We really appreciate you making the drive from beautiful Summers in Monroe County today. And with that, counsel, you may begin.
Good morning, Your Honors, and may it please the court, Caleb David for the department. I'd like to reserve 5 minutes for rebuttal. The circuit court exceeded its legitimate authority when it ordered the department to provide information for what would have become a judicial investigation outside the lines of 2 abuse and neglect cases. No party filed a motion. No party claimed the department unreasonably delayed filing a petition. The circuit court started an investigation of its own accord and for its own purposes. These are abuse and neglect cases. Nothing in the court's laundry list of information demands has any bearing on whether the parents abused or neglected their children, whether the parents should receive improvement periods, whether they've complied with the terms of those improvement periods, or what disposition is in the children's best interests. The circuit court ordered the department to produce a comprehensive list of all CPS referrals for which no action has been taken, the dates the referrals were received, the nature of the abuse or neglect reported, a list of investigative workers in Berkeley County, the number of vacancies for investigative positions, and a statement regarding whether the Berkeley County CPS office is receiving adequate support and resources from the department on a local and state level. And these orders were entered for the general purpose of exercising general oversight over the department, and the circuit court lacks that authority. The executive branch supervises the department, and the circuit court's attempt to usurp that function violates the separation of powers. This court should issue a writ to prevent the circuit court's judicial overreach. Now, this court has never hesitated to use the separation of powers doctrine to curtail government actions that violate it. And this court has said that where there is a direct and fundamental encroachment by one branch of government into the traditional branches of another branch, into the traditional powers of another branch, it violates the separation of powers doctrine. And the circuit court's orders here are a direct and fundamental encroachment by the judiciary into the traditional powers of the executive. We have 2 separate cases with completely different parties, none of the information pertained to any of the children in the proceedings. It was entirely external to these 2 cases, and it was an external to any case because, again, the information related only to children for which a petition had not been filed. So the circuit court had no judicial reason to craft these orders, and the circuit court responds that when it believes the department hasn't acted quickly enough on referrals, it should and must take action. So it believes that it should order the department to produce information unrelated to any pending case, receive that information, and then, quote, attempt to fashion a remedy. And it bases this belief on the intertwined obligations of the department and the circuit court, and that's wrong for a few reasons. First, courts only act where there are justiciable cases and controversies. Article 8, Section 6 of our Constitution recognizes that requirement. And to be sure, there was a pending case before the circuit court, but the orders had nothing to do with either of these cases.
Counsel, before you move on, what remains to be resolved in those 2 pending cases, if anything?
Nothing. Both of those cases have been dismissed post the rule to show cause order being issued by this court. So there's nothing to be resolved in those cases. The only thing to be resolved would be the original jurisdiction petition before this court.
Thank you.
So this action by the circuit court wouldn't be any different to a circuit court sua sponte ordering a defendant in a red car, blue car case to produce to the court information about its divorce. It has nothing to do with the case. It's engaging in judicial discovery, not the parties engaging in discovery, the court engaging in discovery itself, and that's not permitted by any of the rules. And second, fashioning a remedy without an underlying cause of action typically results in an advisory opinion. This court doesn't issue advisory opinions. Circuit courts lack that power. But the circuit court's remedy here goes beyond that into actual judicial control of the executive branch. And it's similar to what we saw last year in this court's decision in State Ex Rel DHS versus Wilmoth, where circuit court had sua sponte issued an administrative order requiring DHS to keep open a facility that it had planned to close. There's no difference between that case and this case in effect here, because they're simply making orders for their own purposes without a party coming before them and making motions, filing a claim, asserting a cause of action.
So counsel, just to make sure I understand, the department have a different position if one of the parents or the guardian had filed a motion and said the department didn't make reasonable efforts during the investigation related to the filing of the petition and the reasonable efforts obligations weren't satisfied, would that give the court the authority then to, in making reasonable efforts determination and the oversight that's granted in that context, would that be enough? Or the department's position is that's not enough to allow the court to ask these kind of questions?
So I think there are two parts of that. First is that it wouldn't be appropriate in an abuse and neglect case, because what a parent would be asserting there is on behalf of a child that there was some violation of the child's rights, and that would be more properly asserted in a civil case. But on the reasonable efforts part of this, that's not a determination of whether there were reasonable efforts made pre-petition. There are considerations in permanency planning for whether there are reasonable
There's
efforts.
actually three. One of them is that the preliminary hearing, the court has to make determinations about whether reasonable efforts were made to prevent the removal.
Right.
So that's a pre-petition action.
Correct. So whether there was an effort made to prevent the removal, not whether they should have made a removal sooner. And that's what all of those reasonable efforts within the statute are talking about, is preventing removal, particularly when you're looking at dispositions 5 and 6, reasonable efforts to reunify the family, looking at permanency planning, whether reasonable efforts were made to place a child up for adoption or to ensure that they're with a legal guardian rather than in foster care. Those are the reasonable efforts determinations. None of it relates to whether there was a speedy investigation or whether there was an investigation that the court would have agreed with the conclusion. And that's the other part of this. And it's similar again to the Wilmoth case, because it really sounds like a mandamus action. And in the Wilmoth case, the court said that there's no non-discretionary duty on behalf of the department to keep this facility open. And here, every decision that they make, that DHS makes, CPS makes, when they're going to file a petition, except for potentially aggravated circumstances, but absent those, every single one of those is discretionary, whether they believe that abuse and neglect occurred, so that they have the ability to put that truthfully in a petition to bring that to the court and ask for the court to take some action on behalf of the children. So those are always discretionary decisions, perhaps absent aggravated circumstances.
So, but to the question I was asking, you're saying that even reasonable efforts determinations, that the court doesn't have the authority to do what it did in this instance under the reasonable efforts rubric.
Yes, that's our position in this. And finally, on the last point about where the circuit court is saying that they have these overlapping obligations to act in the child's best interest, and that's certainly true, and see that's CPS's obligation 24/7, but the circuit court's obligation doesn't extend outside its constitutional role, and that's the problem here, is that the court was taking action that it believed to be in the best interest of children in Berkeley County, but it went beyond its constitutional role in doing that. And the circuit court's orders also intrude upon the legislature's choice to place certain powers in the cabinet secretary. The legislature made the cabinet secretary responsible for administration of the department, including staffing and personnel decisions. Those legislatively conferred powers include the power to delegate authority to individuals to oversee specific offices, oversee specific personnel, and the circuit court lacks the authority to take that power away that was bestowed upon the department by the legislature. The department meets the other Hoover factors as well. The department has no other adequate means of relief or to obtain relief, and the department will be damaged in a way that's not correctable on appeal. As we have discussed, these cases have both since been dismissed. There wouldn't be an opportunity to appeal, but there's also another legal and practical reason. Legally, the harm here is immediate. A constitutional violation occurs as soon as the department is required to comply with the orders, and another one occurs when the court enforces the orders. And this court has recognized that constitutional deprivations are irreparable harm. That's not even the standard to issue a writ, but there's no reason to treat this constitutional deprivation differently than another one.
Counsel, you argue in your brief, essentially, this is information that is available pursuant to a FOIA request. So what is the harm here if a judge is seeking it via an order versus a request any citizen can make?
So some of the information is available, not all of this information is available via a FOIA request, but the harm is that the judiciary is acting outside of its proper scope. It's violating the Constitution, and that's always harm. Separation of powers is fundamental to our Constitution. It's fundamental to ordered liberty. It's fundamental to the rule of law. And when a circuit court steps outside of that, there is harm every single time, and particularly in this case, the department was the object of that. And so the court is, the other part of that is that the court said that it intended to fashion a remedy. That's what it said in its brief. And again, there's no claim, there's no cause of action, but the circuit court made clear in its initial response in this case that it intended to fashion a remedy once it received this information. So stopping that before that starts is important, and it's important for the practical reason of why there's harm here. It's not clear, even if these cases weren't dismissed, it's not clear when a direct appeal would have been available. The court could have started its investigation, requested additional information, subjected the department to a series of interlocutory orders, and then eventually dismissed the case and entered a final order only when the circuit court was satisfied that the department had met what the circuit court believed to be the appropriate standards. So by that time, there's nothing to appeal. And for a period of years, potentially, there's been judicial oversight over an executive department branch. And then there's also one additional harm that's not directly to the department, but it would lead to prejudging cases. And if the circuit court is going to review and determine whether it believes that the department should have been filing a petition or should have filed one earlier, then that is prejudging before we get to even a preliminary hearing, let alone an adjudication. And this is clearly an oft-repeated error. We've got two cases here. The circuit court said in its response that it did file a similar order or issue a similar order in a third case. So the court appears to want to enter this order anytime it disagrees with the department's investigatory speed. And we already discussed that this raises important problems of separation of powers. So the court should grant the writ and prohibit enforcement of the circuit court's orders. Now,
You have about 6 minutes.
okay. I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
May it please the court, Chief Justice, my name is Zach Ritchie. I'm here on behalf of Judge Redding, and I'm joined today by my colleague Andrew Tessman. This case is not about courts running executive agencies. It's about whether a circuit judge may obtain information necessary to carry out mandatory duties to protect the children appearing before him. The challenged orders require information only. referral backlogs, investigative delays, staffing numbers. They do not direct hiring. They do not control budgets. They do not mandate operations. They do not impose remedial plans. Information is not administration. And the separation of powers prevents courts from running agencies. It does not require them to operate blindfolded. The rules in Chapter 49 do not envision passive judging like my friend here argued today. They impose continuous, evidence-based supervision over departmental performance. This is not institutional reform, it's institutional visibility. The rules of this court and the statute in Chapter 49 require courts to make findings concerning timeliness of investigations, reasonable efforts of the department, and including child safety on an ongoing basis. Chapter 49 assigns courts the duty to protect children, not simply to rubber stamp agency assurances. The rules impose a continuous obligation on courts to make these evidence-based findings about departmental performance and child safety. And a court cannot make these while being blind to whether the department is structurally incapable of performing its statutory duties. And Judge Redding did exactly what the law requires. He sought the information necessary to determine whether statutory protections were real or if they're illusory. And the department is essentially asking this court to bless blindfolded judging. Now, we will concede under the separation of powers, of course, courts cannot force the agency to hire workers, set budgets, or certainly not run the department. That is within the executive branch's powers. But these orders do none of that. They don't dictate policy, they don't require remedial action, they don't impose an oversight regime. They simply require disclosures, and that distinction matters constitutionally.
Counsel, you'll concede that these orders do not pertain specifically to issues in the cases in which they were issued. They are much more broad. So to say that these orders were fashioned to allow the court to make a decision in these specific cases is kind of a broad brush, isn't it?
And I agree with that, Your Honor. I'm not claiming that they are specifically fashioned for these particular cases. These orders are fashioned to address, well, to become informed about structural concerns. Judge Redding has been in this world, the abuse and neglect world, for a long time, both in practice as well as a judge. He has worked with the department over many years in that county, in that circuit, to address very serious institutional, structural issues with the agency that can impact future litigants as well as current litigants, children that are involved. And so this structural inquiry into the structure of the agency, it goes directly to whether it is capable of performing its job in individual cases that may arise. And that is consistent with what this court has done in the past. This court has in its institutional reform cases, has absolutely blessed the compelling of jail capacity data, hospital bed availability, mental health placement information, and none of that runs an agency.
Counsel, don't we have a very serious nuance here that no one asked for this? This is not institutional reform litigation where we have represented parties on either side, and one party on one side asks the court to intervene in a systematic way. Here, we have sua sponte, issuance of orders in cases that you have conceded the orders are broader than the cases themselves require. Isn't that a serious nuance that we should consider?
It certainly is a distinction, Your Honor, from this court's precedent in institutional reform cases, but each one of those are quite different from each other. And the question here really is about the scope of the judicial power. And as those cases show, the scope of the power goes well beyond particular individual cases in which those remedial orders and plans arose in. Those were largely mandamus actions But effectively here, what the court is doing is, to my colleague's point about no cause of action, is this court should construe these orders as essentially mandamus to the agency. And that is similar to the institutional reform cases that this court, again, has for over 30 years, including as recently as 5 or 6 years ago with the Hartley litigation from Kanawha County. That went on for 40 years. This court unanimously blessed the circuit court's intervention there, which was certainly much broader than the original case, whose parties were long gone. And so these orders are perfectly consistent with this court's blessing of that sort of institutional reform. Each case is different, and there may be procedural or subject matter jurisdiction issues that arise, but as a matter of judicial power, these orders fit comfortably in the court's precedent. To my colleague's point about FOIA, it's a public transparency tool, and disclosures, discovery orders, and the like, these are core adjudicatory functions. Courts don't become members of the public just to seek information that are relevant to the statutory duties and powers. But relegating a circuit judge to FOIA essentially subordinates the judiciary to executive branch discretion. So I think that really inverts the separation of powers.
Counsel.
Yes, Your Honor.
It seems that to an extent what set Judge Redding down this path was in the first case, there was about a 16-month delay between the initial referral to DHS and the filing of a petition. And so the court had concerns characterizing that as a substantial delay. And it seems as if the questions in the court's mind, in the circuit court's mind, were why is this delay occurring and can DHS meet its charge? My question is, I understand your argument that the judge was seeking information. My question is, to what end, and how does that end fit within the constitutional purview of the judiciary?
Your Honor, thank you for that question, and I think it really goes to the reason that this case is premature. We haven't got to that point and may never get to that point. I think it depends on what the information reveals, and the court may or may not take remedial action depending on that. And I think that question, which is a very important question, depends. It depends on what happens. And it's another reason this court should not intervene at this time. It may be that after some remedial plan is adopted, hypothetically, in the future, the agency can come back to this court and say it's inconsistent with statutory, the court's authority, beyond the scope of the authority, and so on. And so I think that highlights why this court should not intervene at this time, at this early stage of information gathering about structural deficiencies that the judge is concerned in Berkeley County, which are serious concerns. The judge's brief outlined how in 2019 there was a serious referral delay and backlog, but he worked and the agency worked cooperatively to help resolve that. But in the judge's view, that is now happening again.
Counsel, from my reading of the rules of abuse and neglect, Rule 3A specifically, there is a mechanism by which a judge can force the issue. If he or she believes that there's an inordinate delay in investigation and referral, Rule 3A allows the judge to force the issue by instituting mandamus in that specific case with that specific child. So if delay was the problem, to Justice Titus's question, why didn't Judge Redding undertake the mechanism in the rules to force the issue in that particular case?
Your Honor, I can't really speak to that. That certainly is an available approach that the rules authorize for the courts to take. But again, I think we're here on prohibition. A clear error is required, and what we're talking about here, and Your Honor's question goes to, is really in the trenches, discretionary acts by circuit judges who are dealing with this on the front lines. And this court should really defer a great deal to judges, including Judge Redding in these circumstances, whether to invoke those sort of procedures. But I agree that is an available procedure that's for circuit judges in these circumstances.
So where is the case or controversy?
Your Honor, I think in these circumstances, the case or controversy here is the disagreement between the court and the agency as to what information is required to be produced so the court can undertake its obligations under Chapter 49 and the rules. There are certainly current and pending cases before him under 49, under Chapter 49, and there certainly will be some in the future. And so these orders go to the structural deficiencies that the court believes exist, and he's trying to learn about what those deficiencies may be. So I take a broader view of the controversy here that should permit this court to resolve this issue and permit the circuit judge to follow through and let these orders be enforced. Just a few more points on the Hoover factors. I think, again, highlighting the prematurity here, I think if the court intervenes at this point, there will be no way to sort of know what the court is going to do with this information and how and whether that might be used for any kind of remedial plans that this court has blessed in numerous cases in other institutional reform litigation cases. We're really at the starting gate here. I think it would be better to allow the court to proceed below, and should there be some issue with a remedial plan in the future, the department can come back to this court to seek a writ. I do not believe, at worst here, we're talking about, in terms of legal error, a scope of inquiry based on broad language in the rules and statutes. An arguable legal error is typically not grounds for prohibition. And so I would say perhaps on where that is crystallized with a developed record, again, we're not there, so I think it's, again, premature. This case deserves factual development, and so, Your Honors, I would just simply ask that the writs be denied to allow the circuit court to proceed with this simple inquiry of the agency to allow the court to assess whether it is structurally capable of following its statutory and rules-based requirements. Thank you.
I want to start at the statutory duties that the circuit court has. And in the supplemental brief, the circuit court outlined what it believes to be the statutory duties, and it listed several rules and statutes and what those each mean. And we've heard argument just now about the scope of those duties and how they relate to overseeing the department. Rule 3 is the definitions rule. That is cited by the circuit court as something that gives the circuit court authority over the department. It's just the definitions used in the rules of abuse and neglect proceedings. Rule 5 says abuse and neglect proceedings can't be put on hold for civil or criminal proceedings. Rule 11 addresses discovery between the parties, not between the court and any of the parties. And Rule 15 deals with visitation. None of those rules say that the circuit court has the power to investigate the department. The circuit court says that 49-4601 requires it to evaluate whether the department made a timely referral, and that's not true. It talks about what needs to be in the petition and what action should be taken once the petition is filed. The circuit court claims that 49-4604 requires it to make findings about whether the department made reasonable efforts to protect the children. And again, we already discussed that with Justice Ewing about what those reasonable efforts actually are. And the circuit court also claims that 49-4-610 requires it to ensure that proceedings advance in a way that protects the child's safety and are not rendered meaningless by systemic delay. And that is true, but it has nothing to do with investigating referrals. That part of the statute deals with improvement periods and how long they are allowed to last or should last. So there's nothing in the abuse and neglect statute that requires the circuit court to investigate whether the department is conducting timely investigations or whether it has the manpower to do so. The point about institutional reform litigation, again, every single one of the cases that the circuit court cites in its supplemental brief had a plaintiff, had a defendant, had a claim, and asked for relief. And that just simply doesn't exist here. Every single case involved a cause of action and a request for the court to fashion a remedy. No one asked the court to do that here, and the court wasn't deciding any case or controversy or engaging in any discovery, even if that were permitted, that related to the cases before the court. And the circuit court hangs its hat on this idea that it was only asking questions and only seeking information. It didn't have the power to do that. And again, its initial response brief in this case said that it intended to fashion a remedy. And remedies can only be fashioned to resolve claims, and there's no claim here. And finally, to touch on Chief Justice Bunn's question about Rule 3A, that actually was available in the HL case. That one came from the family court. The circuit court had the opportunity to review, and if the circuit court believed that a petition could be filed, mandamus could have been ordered in that case. So that was available. The circuit court didn't take that option. And so for all of those reasons, we ask that the court grant the writ and prohibit enforcement of the circuit court's orders. Thank you.
Thank you. This case will be submitted.